There we go. The floor is yours, Binu.
Okay, so I think the topic today was dealing with divorce and separation issues with respect to representing clients. So some of this, could be self-evident or people might know, but it's really, I think, important to understand avoiding conflicts of interest and to try to sort of identify issues that could potentially be problematic sort of later on in the process that don't seem sort of self-evident originally. The first issue, I think, and like I said, this could be self-evident, is sort of identifying the relationship between the parties and understanding sort of what the obligations are in terms of, executing listing agreements and the agreement of purchase and sale. And the first thing is identifying the difference between married spouses, legally married spouses, and common law spouses. So it's really important maybe to think about it in terms of, because this is a confusing question that comes up over and over over the years, is to think about it in two separate groups. Either the parties are legally married, so they've gone through the process of getting a marriage certificate and the ceremony, everything like that, and then everybody else is sort of piled into a second group. So if you're legally married, you might have two different situations. A situation in which both parties are on title and selling a property. They're both going to sign all of the documents together. If they're legally married and one party is on title, the same situation happens. You're just signing that party in a sort of a different section, where the second party is providing spousal consent. So you're treating those two individuals as sort of a joint representation. You have to understand, sort of taking instructions from both of them and understanding that there may be conflicts between the two of them, maybe not initially, but maybe as time goes on, and making sure that you take record of all of the communications you have with them. And sometimes things might seem very amicable, fine, anticipate that there could be problems along the process. Two parties who are sort of getting along at one point are not necessarily going to have an agreement on all of the things that are going on with respect to the process. I'm going to sort of highlight some of those things that could come up. So that's how you deal with sort of legally married spouses. They're in one box, you're treating them the same, you're taking instructions from both of them, you are dealing with that situation in that context. And then you think about everyone else. So two parties who own a property together, obviously you're getting instructions from both of them in the same situation. If they're common law and one party is not on title, then you have to be very careful about how you deal with that situation. So once again, you're taking instructions from the person who's on title. The common law spouse, you do not need to get consent. And you have to be very careful about their involvement in the situation. Because obviously you have one client who's the person who's selling the property, and you're taking instructions from that person. But understanding that the other spouse, the common law spouse, lives in the property maybe, might have situations in which you have to deal with how are we going to, sort of involve them in some of the parts of the process, the moving out process and so on and so forth. But understanding that if there's conflicts between those parties, you take instructions from the titled owner and obviously the common law spouse. If they need to get legal advice about what their rights are, then they will have to go to a lawyer and sort of determine if they have any rights to that property and what are sort of the steps to deal with that.
Can I ask you a question?
Sure.
So a common law spouse is not required for spousal consent for
Yes.
our purposes,
Yeah.
regardless.
Regardless, yeah, because the law is differentiating between a legally married couple, a partnership, and a common law partnership. And they're saying that, and the confusion I think people have is sometimes those rights between legally married spouses and common law spouses are the same, and sometimes they're different. And understanding when they are the same and when they're different is sometimes confusing and complicated. So I'm trying to sort of separate those two in terms of this context. And it comes down to sometimes even the parties might say, well, we're married. And, a realtor or even a lawyer or whoever might assume that that's the case, but then understanding, okay, well, how do I determine that whether that's true or not? Because even the parties might consider themselves married when they've never gone through the ceremony, got a marriage license, a marriage certificate, all of that, and they're using sort of different terminology that could end up becoming confusing. So then we see situations where, parties have sort of been identified as being married, but then we later on realize, okay, well, hold on a second, they're not. So now we have to adjust things. And the reason why there's that difficulty is that if they're common law, that person sort of assumes that they're married and have these same rights, they might not be so, amicable later on when they start to realize, maybe I don't have the same rights as legally married spouses, and that might also affect where those funds are gonna go at the end of the day or not. So I think it's sort of important to understand that those issues could come up.
So while consent's not required with a common law relationship, is there any harm in getting it if there is? Because some people might get their nose out of joint or.
I think the harm is the sort of expectation versus reality. Because I think the situation is that if you get consent from somebody who's not required to get consent, then the situation is later on down the line, they might have an assumption of that they might be entitled to sort of 50% of the property or something, or that they might have a say in things that you don't necessarily need their say for. So for example, if an extension is necessary, or amendments to the agreement of purchase and sale, or any of those situations. So I think the question is that you can sort of advise that individual, if you meet with them, the common law spouse, you probably should talk to a lawyer about what your rights are. Now, obviously, this situation, I'm dealing with situations where parties don't have a legal agreement between the two of them. That's where sort of it's problematic. If you have a separation agreement between the two parties, it's probably pretty straightforward to follow through as to what the separation agreement says and how they're sort of dividing their property or how they're dealing with those issues. So obviously it's important sort of at an earlier stage to get a separation agreement, but I've seen as time has gone on that that's not necessarily the first step that people are taking these days.
Yeah.
For a variety of different reasons. Cost might be a factor, but they're not going that route. They're looking at it and saying, we have a home, we're living together, we don't want to live together anymore, let's sell this house. And let's deal with the rest of this later. And it could be for financial reasons, it could be for personal reasons, but that's the first thing that they want to do. They want that settled, and then some of the other issues can be determined later on. However, sometimes doing it that way can create multiple issues sort of later on. So, if they have a separation agreement, great. If they're working on a separation agreement, wonderful. If they don't, then we have issues that we have to think about and deal with. Because, if you don't have a separation agreement, and whether you're married spouses or not, issues like, how are you going to divide the proceeds from the sale? These are sort of, relevant factors. And it's not a situation necessarily that the realtor has to get involved in those, but understanding that that's going to be a point maybe of contention later on. That you're involved in hearing about these sort of issues. You're not necessarily going to be able to solve it for them, but it can create sort of heightened tension in terms of a process that we're trying to keep as smooth and calm as possible for everyone. And then those sort of issues.
Christian has a question.
Oh, hi, Christian.
Binu, hi everybody. Hey, Binu, is it automatic the spouse, married spouse is 50-50?
So this is where we talk about, things that are automatic. Under the law, yes. If you're married spouses, it's 50-50. Now, are there exceptions to the rule? Unfortunately, there are. So there's situations in which parties might go to court, or they might have an agreement in which they alter that. So situation number one, they have a marriage contract that says that the division of the proceeds are different. Issue number two, the parties come to a separation agreement in which they've divided things unequally, or there's a court order that says that there's something different. But apart from that, so the baseline is it's going to be 50-50. Married spouses, they're going to divide everything 50-50. In terms of the matrimonial.
one question on the matrimonial home, if they didn't start even, one put in 200,000 and the other put nothing, does it still 50-50?
Yes.
If it's a matrimonial home?
Yeah.
Yes?
That's exactly it. And the difficulty that you have is when you sort of have, it's a little bit simpler when you have married spouses who sort of started everything together. So they've met when they're very young, you had children together, there's been unequal contributions to the home. The law says, okay, it's 50-50, and the parties in that situation sort of kind of understand how that works. They maybe not be happy with it all the time, but they can sort of accept it. Where you have a different situation is where you have second relationships, third relationships, second marriages, and then the individuals get married. A person has maybe pre-existing property that they're living in, and now it's become the matrimonial home. So that's where it gets complicated. That's where lawyers would say, okay, you should have had a marriage contract, but once again, parties don't necessarily start on that, on that side of things. They get married and then they say, okay, well, how do we, sort through these issues? And then the expectations and the reality of, like managing the expectation of, well, hold on a second, am I supposed to split this with this other party who didn't contribute the same as me? Well, unfortunately, it's a reality that they, they face and they have to sort of accept, and they're not necessarily happy about it.
Thank you.
Okay. So yeah, so I mean, the division of funds, like I said, it's not something that you need to get so deep into, but you have to understand that there could be issues that happen because of it. And one of the issues, that could happen is, let's say we have a situation in which we're selling a property and the parties do not have an agreement and there's some dispute about the division of funds. What's going to end up happening at the end of the day, if the parties can agree, wonderful. If they cannot, the real estate solicitor is going to hold their funds. So that, once again, not a huge issue for the realtor to deal with. The lawyer is going to deal with holding those funds and getting instructions, whether it's eventually a separation agreement or a court order that deals with the division of those funds. But secondarily, maybe for a realtor, they have to understand that's going to have some effect in terms of if there's a secondary transaction there. So if these two parties are selling the property, they have a separation agreement, yes, they have access to those funds, they're going to get their money when the sale closes. But if they don't, and they have a dispute, then they're not going to have access to those funds. So if you've now represented a client, on a matrimonial home sale and a divorce and separation situation, and one of those parties is now purchasing, and you're helping them with that transaction, okay, well, what are the issues that we have to deal with there? So if they have a separation agreement, they get access to their funds. If they do not, then their funds are not going to be necessarily readily available for them. So now you have a situation where you can't necessarily guarantee that that purchase is going to close, though the clients might have some expectation that they thought at the beginning it would be, an easy process. They would get their money and be able to purchase something, sort of simultaneously with that.
So in that case, does that mean that the real estate lawyer must see the document to know how he is how to disperse the funds?
Yep. So the real estate
It's
solicitor.
like a legal requirement.
Yep.
Yeah.
So the real estate solicitor is going to ask if they have information that this is a separation for the separation agreement, and typically will also create a secondary document, some type of direction that's going to say, okay, you have a separation agreement, the parties are agreeing to this division, whatever the division is, have the parties sign it on closing or before closing, so that confirms what the separation agreement has. So have the separation agreement, we get them to sign to confirm that, and then we're ready to go. We can then close the transaction, release the funds to the individual parties, and they can do what they want with it. So, that could be a situation. I mean, we have clients who, their matrimonial funds are still in our trust account many, many years later. And they sit, and we're waiting for instructions and we follow up. But, we never know when those funds will be released. So it can be a very quick process. It can be, quite a lengthy process to deal with that. And then obviously there's, this is maybe less common, but there's also a situation where when those parties are selling a property and purchasing, there might be a situation where they need bridge financing for it. So they want their purchase to be before the sale. Okay, fine. Being careful about the fact that you're typically going to have both parties on the sale sign all of those bridge documentation. Typically, a separation agreement will not have contemplated bridge financing. So they have a separation agreement, it says we're gonna sell this property, we're gonna divide the funds. The parties on their own decide, okay, well, I want a bridge. They go to a bank and they say, okay, well, I want to get bridge financing in place. Maybe their realtor might have suggested that for a variety of different reasons. And then they realize, okay, to get this bridge financing done, I need to go back to my partner and have them sign that. We've never agreed to it. Now we're reopening a negotiation. Maybe they might be happy to sign the bridge financing, maybe not. And it can be an issue where, if there's a conflict, maybe there's an issue. And it could be an issue where both parties want to have access to their funds. Both of them can't bridge. Only one of them can bridge. So now you have a situation where you might be in a situation where you've advised somebody, okay, well, maybe this is an option, but be very careful about whether that's an option you want to present to them, or if it's something where you want to say, okay, well, we really need to, before we even go down that road of bridging, we want to make sure that everybody's sort of on the same page, or just say to them, you know, you need to talk to your lawyer. If you want to bridge, you know, it's probably best to go through your lawyer to get that done, but maybe not, you know, even, you know, suggest that if it's not, you know, an option that you know for sure is possible. Because I've had situations where eventually the other partner signs, but there is difficulties. There's difficulties in terms of, should I sign, should I not, what are my rights, who's gonna pay for the bridge loan costs, all of the things that sort of are dealt with, because typically that bridge loan is gonna be paid back on the sale of the property, and then there's interest and costs that the bank is incurring. How is that going to be dealt with between the two parties who are splitting their funds? And it's already not been contemplated. So just be careful, because we've had situations where, so that suggestion of bridging is there, but in a divorce and separation situation, you might want to say, okay, well, let's put that in our back pocket, maybe not necessarily consider it unless it's something that we know the parties, you know, in advance are in agreement with. It can be problematic that way. So, and then I think the last thing that I wanted to talk about is, you know, what happens in situations where parties have conflicts right at the time of closing. So let's say they have a situation in which they have signed they have a separation agreement, they've signed a listing agreement, they've signed an agreement of purchase and sale, and now we're getting into the nuts and bolts of closing the transaction and getting these two parties out of the property. And sort of the common things that we might see are sort of the issues that they've not discussed, and it comes up over and over and over again. So maybe they have a separation agreement that says, we've divided our household contents to our mutual satisfaction. Doesn't really mean anything. But on closing, you have this common problem of party A removes their items, they've come to some type of decision as to what those items are. Party B removes their items, and then there's this third group of pieces of property that nobody wants. And how are we going to sort of deal with that? So on closing, and it happens very common when there's a separation, we have a letter or communication from the purchaser's lawyer saying, there's still stuff in the house. And neither of your clients are attending to that, whether that's before closing or after closing. These are issues that you may want to just mention to the parties and say, fine, you're going to be moving out, you're going to be dividing your items, but you got to have an understanding that everything will have to be removed, whether either party's taking it or whether that's going to be disposed of. Because once again, just other issues that realtors end up having to deal with, emails, texts back and forth about those issues, and maybe if we anticipate those problems in advance, then we can sort of deal with it. Because it's just sort of the general items they don't want, the cleanup of the property, just disposing of things, that's going to sort of always, I think, be an issue. issue that comes up sort of over and over and over again. And the last thing is just in terms of the issues that we sort of see as, more common these days are issues like amendments to the agreement of purchase and sale and extensions of the closing date. So just be aware of, the conflict that could happen between parties, in that regard. Amendments, once again, it's probably best in all contexts to, whether it's amendments or extensions, to talk to the real estate lawyer beforehand, before signing anything. It's safer for you to go down that route as opposed to getting instructions from one or both of the parties, and then they might change their mind as time goes on. So it's just probably better to just say, okay, the real estate lawyer is going to deal with those issues, as opposed to sort of giving advice one way or the other about that. It can be just too problematic to just be in the middle of all that.
Christian's had a question.
Hi, Kristen.
Binu. I just want to recap. I have this argument every single time. What's the main difference between common law? Everyone thinks they're married, and I keep saying, no, I don't need anybody else's signature, whoever's on title. I know there's going to be issues afterwards, but at what point does a common law have some rights or any rights?
You have to assume that they have none unless there's some type of an agreement or court order that says that they have rights.
Okay, that's what I thought. That's what I keep telling, but I got these people saying, oh, after a year, it's like being married. After 2 years, it's like being married. I go, I'm reading the title. There's only one person. That's who I'm dealing with. And I suggest you get a lawyer.
It's the problem with, I say this all the time, the truth is really hard for the truth of the law to get out to everyone. Most of the time it's these falsehoods and misrepresentations as to what the law is that gets out to everybody. It gets repeated over and over and over, and it sort of gets ingrained in what people's thoughts are. But the question obviously is that you sort of have, you're always going to, and a lawyer has the same thing, you're always going to have to fight against those things. The misrepresentation, the misinformation that's out on the internet, even before the internet, just things that people used to talk about. Well, I went through this during a separation, and this is what happened. Every situation is completely unique and different, and there's different factors that are involved. But when you're dealing with a situation where you have common law spouses, you're going to sort of just go through the analysis of, are they legally married or not? Do they have a marriage certificate? You might want to take a look at it and take a copy of it, just for your own records. If they don't have any of that and they say they're common law, then you might want to pull a property search to see who the title owner is. You're taking instructions from them. You're saying to the common law spouse, I think you should go see a lawyer. I can't give you any more advice about this, about what your rights are. Let that person meet with a lawyer, have a consultation. Maybe there is a negotiation, because there are complicated legal rights that they may have, but you have to, as a common law spouse, sort of address those and bring those claims out, as opposed to a situation where married spouses don't necessarily have to do that. By virtue of the fact that they're married, they have these sort of rights attached to them. In common law situations, you've got to prove your claims. So if you put money into the property, and you believe it would be unfair for this property to be sold and the title owner get everything, you got to bring those claims, you got to prove those claims, and then show that you're entitled to that money back that you put into the property. So it's one of those situations where they really do need to talk to a lawyer about this, that situation. It's so overly complex for anyone to sort of be able to make a determination or sort of look at a situation and say, well, yes, it's definitely in column A. It's just too complex to deal with that. And so that analysis has to be done with a family lawyer typically, and sort of avoided any other way, because otherwise any type of advice or any type of leaning one way or the other can just cause more confusion. And I see that all the time. I have clients who come in on family law matters and they're just sort of all off in left field as to what their belief is. And they sort of need to be refocused and sort of given what their options are, as opposed to sort of coming in with these sort of false expectations.
The fact that there's kids or no kids involved doesn't change anything, does it?
No, it doesn't change anything. I mean, I think that when it comes down to it, there's sort of some practical issues there and some sort of logical issues of sort of how that's going to work. But I think that in the end of the day, when it comes to the law, it's the same situation. How does that partner, that common law partner, address their claims? How do they, make those claims? So sometimes it's a situation where titled owner in a common law relationship wants to sell the property. The, non-titled common law spouse doesn't want to. And they have children and they may not be able to find, appropriate accommodations. And the title owner is like, no, I'm gonna sell this property, I'm gonna take my money, I'm going to go wherever, and away you go. Not always the case, but we've seen sort of more of aggressive situations like that. And then so that non-titled common law spouse has to deal with it. And they have to make those claims in court. And maybe they have a situation in which it's not necessarily gonna stop a sale of the property, but it might deal with where that money is gonna go at the end of the day. But if that non-titled spouse, common law spouse, wants to stay in the property because there's some issues in terms of moving, and sometimes there are those unique issues that sometimes come up, they can't find an appropriate place to live or whatever, they've gotta bring those claims. And they have to, have a judge typically make an order that either, stops the sale of the property or, gives a process in which that's gonna take place in a timeline. So
Okay.
it's, it can be, having kids can complicate things, it can put a twist in things, but it's not necessarily gonna stop the process, it might elongate the process a little bit, and they need to have better clarity as to how that's gonna work.
And one other part, on a common law purchase where both of them are on title, is it 50-50? If both of them are on title, no other agreement exists?
If they're common law and they're both on title, the presumption is it's a 50-50 split. Now, the difficulty there again is it's not always clear cut as to how that's going to work. So when you're common law both on title, one or the other party might make a claim to say there should be an unequal division. I put in more, and the court will consider that in a common law situation. In a married situation, when they're legally married, they're not typically going to consider that unless there's some real unfairness and you meet sort of a really narrow exception to the rule in that case. And so it's a little bit more difficult. But in common law situations, yeah, they're going to look at factors like, if they're both on title, the difference in down payment between the parties. They're gonna look at what their contributions to the parties were, renovations, all of those individual factors. Very complex, very detail oriented, very evidence-based, so it can get quite complicated.
It's all lawsuits either that you're talking about.
Sorry?
That would all be going to court cases, so straightforward, just 50-50.
Yeah, exactly. So it's just one of those situations where you have to deal with it. So for example, a court might make an order that says, this property is to be sold, and this is how we're gonna deal with the funds. Some of it goes to party A, some of it goes to party B, some of it's gonna be held until all of these claims are determined. So there's a variety of different ways that can be dealt with, and but the parties have to, very quickly, once they start to decide or come to a decision to sell the property, deal with those or come up with some type of solution.
Okay, thank you.
I have a question.
Yes.
I have a couple that we're working with. They're divorced. She's been living out west and he's in Turkey right now. So we submitted 2 offers on the property and they didn't acknowledge it at all. It was from the same agent. And this listing is co-broked with another agency, Harvey Callis downtown. So now we just got some information that the wife is going to sell her shares to her husband. They haven't been upfront. We look unprofessional as agents because they totally ignored the offer. And I felt sorry for the other agent bringing it in. And I wanted to know where we stand if Mr. Seller buys out the property from the wife. There were no exclusions. The other agency wants to claim commission. Where do we stand on that part?
I think it's complicated at that point. But
I think so.
I think the question is between the two parties, since they've signed contracts, they have to understand that if they're gonna do a buyout of one party's interest, they have to deal with the individual contracts that they've signed. So if husband in this case who's in Turkey is buying, wife in Alberta's property or out west or whatever, then that has to be part of that sort of agreement between the two of them. So if the buyout is, I'm gonna give you $100,000, okay, well, how are we going to then deal with the other funds? Now, I think the question is that if you get sort of word or wind of this taking place, and typically lawyers are gonna be involved in sort of negotiating that, maybe those lawyers need to be aware that this is an issue that needs to be sort of rectified or dealt with. So they don't just deal with, okay, what's the value of the property, what's wife going to get in this situation, and then we're done with it. No, we have a situation where there's sort of these third parties that are involved and we have to deal with the situation. So it's not a situation where, now husband is, the full owner of the property, it's been transferred in his name, and then, one brokerage is sort of looking and going, well, what do we do now? Hold on a second, what are we doing in this situation?
Yeah, it's kind of, it's a funny situation because if they leveled with us, that's a different scenario, but they didn't. They just played it along and then then they keep saying, show the property. Like I got upset, I ordered the sign down at the property still being shown, but why show the property? Why bring in another offer if they're playing games? And the finale is the agent that's co-listed, she's looking after Mr. Seller, and so's her husband, who is a lawyer. And then we are on the wife's end because that was a referral from our lawyer. So I don't, what? It's really a complicated issue. Right now, we wrote back and said there weren't any exclusions and it's fine what they're doing, but level with us is they're going to be a buyout, but take commissions into effect.
Yeah.
There's not much there, but whatever.
Yeah.
I don't know.
Yeah, and sometimes I'll be honest with you, sometimes lawyers can be very, myopic when it comes to these things. So one of their clients comes to them and says, well, I just want to buy out the other person's interest. And the lawyer doesn't actually think about all of the issues that are involved here. So they sometimes have to be gently reminded about, okay, there's these contingent issues that are out there. And they just sort of get laser focused on, okay, I just want to do this for my client, that's it, as opposed to seeing sort of the full view of the problem or the issue. So they have to be reminded, okay, well, you got to take into account these legal relationships and contracts that have been signed and to deal with it. And assuming that they will is probably a bad thing to do, because we see it all the time where they just sort of kind of forget about all of these and then are scrambling at the end of the day to figure it out.
I'm just thinking too, what they could do is just wait till the listing expires and then close after the 60 days or whatever, It's hard to say because there is conflict, because the other agent, it's her husband that's, working with one of the sellers. So that's a little bit of a conflict there.
The difficulty is, and I don't know the specific instance here, but sometimes you have one party who's like, oh, well, I need to be protected. So I have my own lawyer and my own brokerage, and on the other side, they want to be protected. But sometimes later on in the process, and I'm not saying this is the case, if they're talking about a buyout, sometimes they have selfish views as to how this is going to take place. So sometimes husband and wife who are sort of in disagreement initially now have some type of an agreement to now cut somebody out and go, okay, if we cut out this other party that you have a legal relationship with, maybe I can get more money into my own pocket. So I've seen that situation happen as well when they look at the sort of the bottom line, and now they have a conspiracy together as to say, okay, we wanted all our protections, but now we don't really need them because you're buying me out. Okay, give me more money and I'll get rid of that relationship. So I'll let the listing expire and we'll deal with it. So it can get quite complex depending on what the sort of the
Yeah.
circumstances are. People aren't always honest about what their intentions are, and they change, so.
Yeah, that's the problem. Thanks.
Yeah.
I have a quick question. A common law relationship where there was a contract drawn up, common law contract drawn up, and then later they marry, and does what was stated in the contract have legs if there is a separation down the road?
So if we have a situation where we have two parties who are in a common law relationship, they have entered into a cohabitation agreement.
Yep.
And now they get married, you gotta look at that contract, that cohabitation agreement. Typically, in the first page or in the first section, it will say something to the effect of, in the event that the parties get married, this cohabitation agreement will be considered a marriage contract, and so on and so forth. And it can be different in all contracts. Some say the whole contract is to continue, some say certain parts of the contract will continue, but you have to see the legal language. If you do not have that clause or anything that says that, you can assume the parties do not want that contract to continue. Their decision to get married sort of voids everything there, and now we're dealing with them as two married spouses, and you know,
Okay,
their rights under the Divorce Act and the Family Law are going to.
okay, because I did have that years ago where there was a cohab agreement, and then they got married, and then everything went to 50-50, and I know there was some really hard feelings there. I just wanted to know.
That there can be hard feelings. It's a difficult thing, and it's a difficult situation for me as well. Is clients sometimes, despite the advice that we give them, despite what we want them to understand, either do not believe it's important or do not understand exactly the ramifications later on. They say, fine, we're fine. Lawyers have explained it on both sides, and then later on, because of the difference in circumstances, and now they don't like each other, now they're looking at it and saying, well, that's not fair.
Yes.
But, you know, it's just one of those situations where, and that happens, it's parties agree, they get all their protection and so on and so forth, and then later on they go, well, I'm not happy with that.
Right, so they should read that contract. Or at least let us have a look at it to see where it stands.
Yeah, and there's a lot of parties who they've signed a contract, they've had lawyers have explained it to them, we give them summary of what the advice is, and years later, they have a complete different understanding of what's in that agreement.
Yeah.
They've just completely forgotten. They will even say things to me like, well, I believe it's this, I didn't read the contract recently, but that's what I believe it is. And I say, well, let's pull it out. Let's take a
let's have a look at
look. Let's take a look at what it actually says, and they're completely shocked. So we have a situation, and I've said this before, where people have an aversion to reading, and they don't want to, and they are scared of it because of what it might say. But sometimes you have to, you know, put that in front of them and say, okay, let's read this together. Yes.
All right. I have a question regarding common law relationship, and maybe it's one of those mistaken impressions, but I was of the impression that when someone moves into someone's house and they're not on title, and then if they split up from the moment that they moved in and contributed, you know, say paid half of everything, that they were entitled to half of the increase in value from that move-in date.
No.
They're not.
Everything is dependent on the circumstances. Because when we think about it, you have to understand, you know, for a lawyer, we look at it and say, the common law, the contract, property rights are on one side of the ledger. And then parties have equitable claims. And what equitable claims means, it's the court's ability to be creative in terms of how they're going to decide this case. The common law and the contract does not fit this circumstance, so now we're going to be creative on this side as to what the result is. So you can see a variety of different results in the same sort of fact scenario that you have there. You have situations in which parties can get their contributions back, but not entitled to a division of the property. And then you have other situations where, yes, the court will say, based on different factors, maybe they are entitled to a percentage of the proceeds, and what is that? And some of the factors are, the length of the relationship, the integration of the finances in terms of how the parties are dealing with things, are they sort of mutually agreeing on things as with respect to the property as time has gone on. So there's a lot of different factors the court's going to look into and say, okay, if they hit some of these, we're going to consider it more of a situation where one of the parties, the non-title party, might be able to get, a percentage of the property. And sometimes, let's say it's a short relationship, and the court will say, you know what, you're going to get your contributions back, and that's it. So we're going to put you back into your original position, all your money's back, but it's still this party's, the title party's property, and they get the proceeds. So there's a variety of different ways to deal with it, and it's always fact specific.
Well, it's reasonable to think that somebody has to pay something to live somewhere. I mean, if they weren't living there in that common law relationship, they'd be renting an apartment or something, they'd be paying something. So to get 100% of their contributions back, we see is not fair.
Yeah, I mean, but you see strange decisions of the court in these situations. So you might have a situation where one party has given up their ability to advance in their career to take care of children or take care of the home.
Right.
And then the court's gonna look at it and say, well, okay, I'm gonna come up with a creative solution to compensate this person. So now we have a situation where if we just give them back their contributions, or we take their contributions and we deduct something for their living costs, where, well, maybe that's not fair. And I've seen judges do this, where they go, I'm gonna be creative in this situation, because I want party B, maybe it's the wife, the common law spouse who has children, to not be in a situation where she's struggling in another, situation. And then, maybe the husband is sort of has all the financial advantages. So they're gonna get creative depending on the circumstances. And I've had judges say, where we sort of advance a claim, and judges say, well, you can't expect them to, move out right away. And they have kids, we have to wait until, certain things happen. So, and you look at them and you go, okay, well, that's a new one. That's, creative in terms of what the law says, but they can do what they want. So that's where it gets complex, where somebody's gonna say, well, I know I'm gonna have these rights. Not really. You go in front of a judge, they can get very interesting and creative as to what their solution is. And sometimes it can be off the board sometimes. So it's a little bit of a gamble sometimes. But obviously the person has to advance their claims, bring their evidence, and hope they have a receptive judge to that. But it's like I said, there's a variety of different outcomes that could happen.
So if there was no agreement in place at the time of closing, the judge would, the realtor, the real estate lawyer would just have to hold the funds, is that right?
Yeah. They need to have an agreement in terms of if they're, married spouses and they're separating, or if it's a situation where they're both on title and they're common law and they can't come to an agreement, those funds are gonna
No,
be.
but I'm saying not on title.
So a situation when they're common law, they're not, there's only one party on title. No, all the funds are gonna go to the title party. The real estate solicitor is not going to take instructions from the non-title party. The only thing that's gonna stop them from releasing those funds to the title party is some type of direction or order from the court that says you cannot release those funds.
So that non-titled party would have to get to a lawyer lickety split.
Yeah. With some, funds in their hands, it's a very, very difficult and complex situation. Because we see those situations happen all the time. It's a long process of just deciding to separate, and then all of a sudden it's a 2 or 3 month process or something that's even shorter, and then that non-title party is like, well, what do I do to advance my claim? Well, you need to get a lawyer, they need to bring an application to the court, they need to probably bring an emergency motion. Very complex, very costly to do. And they have no idea about that process, and then they say, well, it's just, too much money or whatever, I don't wanna do that, is there any other way to do it? And I unfortunately have to say to them, no, it's, if you had an agreement at the beginning, this would have been better. but this is the only path forward, because once that once that title party has all those funds from that sale, who knows where those funds are going? And who knows if the non-title party is ever going to see any of them? You never know. I mean, I had a situation years ago which was very, very similar to that. And there was an intention of one of the parties to sell the property and leave the country. And until the wife in the situation found out about this and went to a lawyer, it was probably 1 or 2 days away from that person selling the property, getting their funds, and disappearing. And then got a lawyer, did what's necessary to sort of stop the funds being released, and that title party was not happy because their plan wasn't able to be effective. But those are the things that sometimes happens. And I've also had situations where, that we have common law spouses where they're selling their property, the title owner is gonna get everything, and they seem to be very happy together. And the property sold, titled spouse gets everything, and then it's over. And I've had that happen before too. So it can be very, very tricky.
Just into almost complete opposite scenario that I've encountered a couple times, just to understand the guidance. One titled owner, but married couple. Titled owner, marriage dissolves right, but nothing, no divorce, no separation agreement. Titled owner moves out of the property, other spouse remains in the property. It becomes a tremendous financial burden to maintain that property by the spouse who's on title and has moved out.
Yes.
They want to sell the home.
Yes.
And they're getting no cooperation on the other side. How does that potentially play out or resolve? Have you ever seen that type of scenario?
Yeah, it happens all the time. So the problem is, and maybe out of the goodness of people's hearts, they sort of come to a resolution or an understanding that we can't live together, we can't physically be in the same home together. So title party says, okay, I'm gonna move out, maybe I have some extra funds, I can find alternative accommodations, and I'm gonna let you live in the property, and then there's maybe some understanding that, eventually we're gonna sell this property, but then the party who's living there doesn't have any intention of moving.
Right.
For a variety of different reasons.
Right.
So title party should get a lawyer, go to court, get an order for the sale of the property. Because the situation is that even if that party, who's the title party, wants to sell the property, they're married, they need spousal consent, right? So now you have a situation where you have to ask the court to dispense with that individual's consent to sell the property. However, the individual who's staying in that property might have a variety of different reasons as to why they can't move out.
Right.
And the court can be very, very lenient as to the time frame to let that party stay in that property. And it can be a long process to sell the property and have both parties find where they're going to live. And so it can be quite complicated.
Young children involved in a scenario like that, I'm assuming would make that even more challenging.
Even in situations where you have a sort of a unique property. So let's say it's a rural property on a farm.
Right.
So an individual is, caring for animals and so on and so forth. And now the title party says, I want to sell this property. The upkeep and the costs and everything like that is just too much. And the party who's living there is saying, well, I have these animals. Where am I going to take them? Where are they going to go? Now you have a situation where they're looking for some type of rural property that they can board these animals and keep those animals, but the options are so limited.
Right.
So it can get quite complex in terms of how long they're going to live and let that person stay in that property. And then let's say they have 4 horses or whatever, the court's not gonna just go, you gotta sell this property, get out. And the horse, the horse is just gonna go wherever. They're just not gonna do that. And so it can get quite difficult, but
I can see the challenges on both sides, right? I mean, you can sort of feel for all the parties depending on the circumstances. Oftentimes, in the experience that I've had, is that there is one party that is intentionally trying to make the situation very, very difficult for the other. And I've seen it on both sides of sort of that fence. And it's more of a spite and an anger than it is out of a need either to sell or to stay.
And sometimes it's just generally a situation where the party who's staying in the property just doesn't want to move. They're comfortable there.
Right.
They're happy and comfortable. They know what their legal obligations are, but they just want to drag it out as long as they possibly can. They don't want to think about all of the steps of moving and doing all of these things. So they're going to kind of sit tight and just not do much and see sort of how this process plays out. And eventually they're gonna agree, but they're gonna make that other party go through all of the time and expense. So the number of times that I've seen people say, well, just let them spend money on lawyers, I don't care. That kind of attitude is sometimes very common because for spite or for whatever reasons.
Right.
And that would be it. But, I mean, if it's a situation where two parties can't live in the same home together because there's some threat of conflict, you know, it might be necessary for one of them to move out,
Right.
just to maintain the peace and so there isn't any further issues that are created because of that. You know, forcing two people to stay in the same house together when they're not getting along is a recipe for disaster.
Yeah, for sure. So basically what you're saying is a court order is really the only recourse for the party, and even then judgment could be for an extended period of time or.
Yeah, that title party who gets a lawyer once a court order has to be aware of the fact that it's not going to be a simple process. And they might think it's a simple process, and they might see a very, very straightforward solution to this, and they're going to be surprised. There's going to be some twists and turns along the way, and we'll have to be prepared for the fact that that's going to happen. And there's going to, you know, if they're carrying, you know, all the costs of the property, that might be happening for a considerable period of time.
I actually am familiar with a situation right now that's been probably closing in on a year and a half to get a court order for the other spouse to sign off on, they're both on title. One spouse is in the house, wants to sell it. The other spouse, basically for about 6 months, they had no idea where. He was playing games of hiding and what have you, and now they're finally at mediation. Hopefully it'll be resolved at that stage and we won't have to go to court, but it has been, we're closing in on a year and a half. And no financial support or anything, she's just hanging in there trying to, you know, found out that back taxes weren't paid and there was all kinds of situations that happened, and then he went MIA, and it's a very, I mean, she's hanging in there, but it's been a long drawn out, and we're not even out of court yet.
Yes.
So, because they had to find him first.
So she was bearing the full financial burden of carrying that property even though both were on title?
Yeah, and of course, finding out that money that was supposed to have been directed to taxes were never directed to taxes, and yeah, it's really become so complicated from where is he to, oh my God. Yeah, and it's just, we met with her on the weekend, and it's just starting to come to a head at this point, and yeah. Whereas, I mean, they're going to mediation and they've had appraisals on the property and there's like $1 million between the prices. And it's like, she says to me, what do you think? I'm like, I'm just backing off. Yeah, and she was a friend, so we just, you go and talk to other people. We don't want to be involved.
Well, the one that Bob and I bought, she apparently, according to her, I've never spoken to him yet, he moved out and he wanted to sell the house right away. And she said, oh no, you insisted that I stay at home with the children. So I'm gonna see out our son's education until he finishes grade 12. And that was like over 2 years. And because she never worked, he had to pay 100% of the cost to maintain that house for the 2 years. I mean, he paid the bare minimum, I'll tell you that, because nothing was done, and I think they basically lived in one room in their house. Because and they used internet from the neighbors and everything, because he wouldn't pay, the kids were COVID and they were now home from university and had to be homeschooled, there was no internet, and it was like, it was a nightmare for her. She did that. She would have been so much better just to have sold the house and moved to some place where her son could have gone to school locally. But, she wanted to put the screws to him and he wanted to put the screws back to her, and so they did. It's messy. It's not nice. And then the value of the house is going down because nobody's maintaining it, because it wasn't possible for her to take care of that huge house and that big property all by herself. It wasn't possible. So, I mean, it got less, everybody got less money in the end. Yeah.
It's the arm of the law that is probably the lawyers need to have I don't know how they can put up with it, because they're probably the most emotional part.
We had years ago, remember, we had clients, husband and wife married legally, she was a consenting spouse, came into the office, they were very happy, they got the little puppy and everything was good, and she signed as consenting spouse, and he was happy, they seemed normal people. And apparently after they left our office, he got in the car and said, now that you've signed off, the house is mine, I'm getting the money. Because it would go into his name because of the check. And so she's like, I'm divorcing you. So he kept a ruse until she signed, and then thought he made it after just signing. And then, of course, the next day, we got letters, and it wasn't that easy for her.
Yeah, I mean, he wasn't the smartest person.
No, he should have waited until he had the check.
Yeah.
Waited until it was in the bag.
Yeah,
And then
but-
the guy living in the country was kind of a smart one.
Yeah.
He got away with it.
Yeah.
So people can be, you just don't know.
You
just
don't.
know.
You don't know.
And everybody
the
has
person.
the rose-colored glasses on in the beginning.
Yes, and then maybe some years, beyond that too.
Yeah.
You just think everything's gonna be okay, but other people have sort of different plans, devious plans, so it can be quite complicated and twists and turns all the time. We see something new every day.
Makes your job so interesting.
Oh, yeah, it does.
Is that what it is?
Absolutely.
Yeah.
Did anybody else joining us through Zoom have any other questions or anything for Binu? Stories of woe?
I want to share tons of stories.
They're all gonna go home tonight for dinner and be really nice to them. Sure.
Well, thank you very much, Binu, for your time, very much appreciate the insights, it's always tidbits to take away. I have to admit, I'm one of those people that I thought a common law spouse had sort of possession occupancy rights to a property. That is
Automatic with children?
with children, I thought that locked it right down, no
Yeah.
question, so it's good to
Know that
Clear
there's
the
no
air.
automatic.
Yeah, no, there's no straight answer, there's no one answer, there's a million different stories in there.
Yes.
So hence negotiate, because you never know what a judge is gonna
So my goodness, tell all your clients, get married.
Well, thank you guys for joining us via Zoom as well, always a pleasure to see you.
Thank
And
you.
I hope you have a good rest of your day, everybody.
Bye-bye.
Bye now.
Bye.
Bye, thank you.
Is this a-
Thanks.
Is this a yes?
Yeah.